cases and so forth. And I just want to make sure everybody understands that those assurances are completely worthless. They are utterly and completely worthless. Those assurances were made in a case called Stevenson, involving a law forbidding certain depictions of animal cruelty. And the government assured the courts that they would only enforce this law against the most, the absolute most indefensible wanton cruelty to animals with a prurient interest in sex, et cetera. And it didn't take them more than a few months to abandon all of those assurances and go after, in this case, Mr. Stevenson just had he had produced a self-made CD documentary about pit bulls that included a very short image of pit bulls fighting. So I want to make sure everybody understands that they shouldn't put any stock whatsoever in the government's assurance that the ATF will only go after obvious violators of this law. There is absolutely nothing in the history of the DOJ's enforcement of laws like this that is consistent with those assurances, and the court has dismissed them correctly, in my view, in other cases, and it should dismiss them in this case as well.
Can I respond to that?
Please do, Drew. Yeah, final thoughts on the administrative law question, and then we'll have closing arguments.
So I don't agree, first of all, that from the standpoint of most citizens, that they have any more awareness of what federal statutes say than what agency regulations say. Most people, if you really want to avoid running afoul of the law, you have to go pay a lawyer to look it up for you before you do something. And whether it's a statute or an agency ruling, and the same, by the way, was a critique of our common law courts that Jeremy Bentham raised in the founding era, that you have no way of knowing what a court is going to decide, what the Texas Supreme Court, for example, will decide. That yesterday they decided that what you're doing is a crime. That said, I disagree that there's a big risk of surprise in the ghost gun, with the ghost gun regulation. The agencies have to follow the Administrative Procedure Act. They have to announce that they intend to regulate something. They have to allow a public comment period. Then they promulgate a final rule, and usually there's kind of a grace period before that goes into effect. So if somebody bothers to look or ask, it is actually pretty clear. You shouldn't be surprised. You can find out. Everyone knows that this regulation was passed, and not only that, the regulation really focuses on commerce, not what individuals are doing in their own home. And so I disagree with the characterization. You have a hunk of metal. Could the ATF show up at your door and say, "Hey, that's a gun"? That's not what the regulation is about. And the companies that are manufacturing these and shipping them, and that's their whole business, they have legal counsel before they act that counsels them, either in-house or outside counsel, that tells them, here's what you can do that would comply with the law and the regulations. I know that they've done that with their workers' comp and their payroll and other areas, their business registration, their corporate taxes. Corporations hire lawyers and who advise them. And so I'm not worried that the corporation is going to be completely blindsided by a regulation of their core product line. They're obviously going to have advice of counsel. And not only that, as the Solicitor General pointed out, now I agree with Clark Neely that there's no legal significance to a Solicitor General promising at oral argument before the Supreme Court that the agency doesn't intend to do something, because after the next election, the agency can just rearrange its enforcement priorities, and they're not bound by that. But you know what they are bound by? If you request an opinion letter from the ATF that your product would not subject you to legal liability, you can go into the court and argue estoppel. It's not foolproof, but courts often do hold agencies to what they promise to individual companies. We approve this product. And so if you are going to invest and buy equipment and hire people to manufacture these 80%er kits, as they call them, and market them, it's just one more little task for your lawyer to write to ATF and ask for approval of what you're doing and have them sign off on, we think that this actually does comply with the regulation, or they come back to you and say, if you change this and this and this, then it would be in compliance with the regulation and you would not have to worry about prosecution. So we don't all just have to sit around worrying, when is the government going to show up at my door and arrest me for something I didn't even know I did. And there was also a significant part of the oral arguments that a lot of the laws that people would actually be charged with do require knowledge or willfulness of a violation in this particular case. And so I think that the person, and it can be a defense to a willful violation in some cases, that you were advised by counsel that what you were doing was legal, or that the agency sent you a letter saying that they thought what you were doing was legal. So it is possible to get legally binding reassurances from the agency about your particular product.
Well, it's time for closing arguments in this great discussion. Clark, first one's to you. Final thoughts on whether or not you think the court should allow the regulation of ghost guns under the Gun Control Act or not, and why?
So let me start by saying that I think that individuals face real exposure to criminal liability under this new ATF rule, and it's not just people who are in the business of manufacturing gun kits. Second, as for being able to get assurances from the ATF, they actually specifically disclaimed in this case a position they took in court 3 years ago in the Southern District of New York. So this is an agency that will flip flop in ways that can be both pernicious and cavalier. But putting that aside, I think that the correct answer in this case, as it is in so many administrative cases, is to say, if this is such a problem, in other words, if the advent of these so-called ghost guns and the increased use of them by criminals is such a big problem, then Congress should be the one to decide how that problem needs to be dealt with and pass a law explicitly dealing with the problem, rather than looking back at a statute that was written 56 years ago in 1968 and say, well, if we look at this thing sideways, we can see a grant of authority to a federal agency to change its longstanding policy about what constitutes a firearm under the statute. I just don't think that's the way we want our government to work in the mine run of cases. Sure, if it's a situation or an issue where you don't like what people are doing, like making guns without serial numbers, it's easy to say, well, seems to me this statute can be stretched to accommodate this new rule. But just flip it even a little bit and take something you care a lot about in the other direction, like immigration or access to medications. And I bet almost everybody in the whole cast of characters in this litigation will jump ship for the other side as soon as this arises in a context where they feel strongly the other way. Watch and see what happens.
Drew, last word to you. Should the court uphold the regulation of ghost guns under the Gun Control Act, and why?
I think so, because these have gone from a situation of a handful of individual hobbyists and metal workers around the country making their own, do-it-yourself firearms, to a whole industry. And the industry, again, is completely thwarting the clear will of Congress to have guns be traceable, to have background checks, to prohibit certain individuals from having guns, to have an excise tax on the manufacturers that is earmarked to be used for conservation and things like that. And so this is, it allows people to be tax cheats. It allows people who lawfully cannot own a gun to easily obtain one. It allows people to essentially get a gun through the mail instead of having to show up in person somewhere. And I think that got traction with a couple of the conservative justices, that if we don't uphold the ban, we're going to kind of say goodbye to the rest of our federal gun laws. And then I agree that in an ideal world, we would have Congress that could do everything for us. But the fact is, we live in a modern age, and I'm actually going to go back to the Federalist Papers and Federalist 10, where they thought the real danger for democracy was not just the majority, the tyranny of the majority or something like that, but was the problem of political factions that they knew most Americans go about their lives like thinking about sports and Only Murders in the Building or whatever the latest show is, and other pop culture things and their families and the next holiday, and aren't really involved in a lot of these kind of nitty gritty issues about that might be pending before Congress about the exact, let's say, reach of the Clean Air Act or the Clean Water Act, or what counts as how complete does something have to be to count as a frame or receiver. They don't think about it at all. And what that does is it allows and they called it factions in the founding era, we would call it special interest groups, to exert way too much disproportionate influence over Congress, and through lobbying and funding of campaigns and so forth. And the agencies are part of our buffer against that, I feel like, and that they give us more protection from special interest groups kind of cramming down their will on the rest of us, just because they are super motivated and organized and have enough money to buy the right number of people in Congress.
Thank you so much, Clark Neily and Drew Stevenson, for a vigorous and illuminating discussion of the future of gun regulations. Clark, Drew, thank you so much for joining.
Thanks for having me.
Thank you, Jeff.
Today's episode was produced by Lana Ulrich, Samson Mastashari, and Bill Pollack. It was engineered by Bill Pollack. Research was provided by Samson Mastashari, Cooper Smith, Gyuha Lee, Matthew Spiro, and Yara Durese. Friends, I am thrilled to share that the NCC has partnered with Khan Academy and launched our new Constitution 101 course. We launched it on Constitution Day, and it's so exciting, and I want you to check it out on the Khan platform. We've brought together the leading constitutional scholars and historians in America of different perspectives to teach the Constitution for free to high school students. And the course is great for learners of all ages. So check it out. It's khanacademy.org/Constitution 101. Take the quiz. And if you find it as challenging as I did, let me know. And also let me know how you did. And always recommend the show to friends, colleagues, or anyone, anywhere who's eager for a weekly dose of constitutional debate. Sign up for the newsletter at constitutioncenter.org/connect. And always remember that the National Constitution Center is a private nonprofit. All of the great work we're able to do is possible only because of the generosity of people like you who are inspired by our nonpartisan mission. Support it by becoming a member at constitutioncenter.org/membership. Any amount, $5 or $10, or of course more, is welcome. And sign up for the great material at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Jeffrey Rosen.